The Defend Trade Secrets Act created a federal cause of action for theft of trade secrets, okay? So just hypothetically, let's just say an employee were to leave your company and take trade secrets. You could possibly sue them in federal court for stealing your trade secrets. In order for you to be entitled to all the damages involved for that theft under the Defend Trade Secrets Act, or the DTSA as it's known, you had to have given the employee notice, sufficient notice. First things first, I'm going to share with you the statute that requires this federal notice. This is section 1833 of Title 18. I just want to show you guys where this notice provision comes from and why it's so key. This is going to be really, really important to all of you employers out there. Anyone that has a possible trade secret where they're disclosing to another possible contractor as well, I prefer to be conservative and to include this language in those agreements. Basically, it talks about immunity. This right here is the notice that you need to provide. How do I know that this is the notice you need to provide? Well, if you scroll down in the code, if you go down to 3, okay, section 3. So that's B and then reference number and 3. You'll see here, in general, an employer shall provide notice of the immunity set forth in this subsection in any contract or an agreement with an employee that governs the use of a trade secret or confidential information. So this section A sets forth the requirement. So this is the notice requirement. So as an employer, you're required to provide this notice to all your employees. What happens, however, if you do not provide this notice? Well, if you scroll down, you'll see there's a non-compliance section. This section governs what happens if you did not provide the notice that was required in A. Well, if you are non-compliant, if you as an employer do not provide the notice, then look what happens. The employer may not be awarded exemplary damages or attorney fees of this section. So this is a big deal, guys. You can't get damages and you can't get attorney's fees if you did not provide the notice. So that's why it's so important that you as an employer provide this proper notice to all your employees, because failure to do so will jeopardize your ability to get damages. Okay. So what is the notice you have to give? Well, the notice relates to when an employee might be required to disclose a trade secret. And if you go up, basically what this is saying is that DTSA does not prohibit or create a private right of action for disclosure of a trade secret in accordance with Section B. So what's Section B? Well, Section B basically provides the reason for why an employee might have to disclose a trade secret and why they'd be immune from the DTSA. So, but basically, an individual should not be held criminally or civilly liable under any, now this is interesting, any federal or state. So even under state trade secret law, you cannot be held liable for disclosure of a trade secret that, now this would be the basis for why an employee would lawfully be able to disclose a trade secret. If the disclosure is made in confidence to an attorney, and this is key, and both of these have to be satisfied, 1 and 2 have to exist in order for the disclosure to be acceptable under Section A, okay? So it has to be made in confidence, another fancy word for saying secret, right? So it can't shout it out or post it in a blog and then link the official to your blog post, right? That wouldn't be in confidence. But you have to, in confidence, so the disclosure is made in confidence to a federal, state, or local government official, either directly or indirectly, or to an attorney. Okay, so everything you tell your attorney would be in confidence. It's either directly or indirectly. So for example, you might make the disclosure to your attorney, who then on your behalf makes the disclosure to the government official. But this and is really important, because this governs the only situation by which this disclosure would be acceptable, okay? And that is, it's solely for the purpose of reporting or investigating a suspected violation of law, right? Okay, so it sounds a lot like whistleblower, right? So effectively, if there's an investigation related to violation of law, then in that situation, it would be possible for the employee to lawfully disclose this trade secret. Again, only in confidence and only to a federal, state, or local government official. Okay, so that's the first main part of the employee notice provision. Here's Section B. The disclosure is okay if it's made in a compliant or other document filed in a lawsuit or other proceeding, if such filing is made under seal. So it has to be made under seal. So it has to be in a complaint or document filed in a lawsuit or proceeding, and is made under seal. In other words, it's not public. It'll stay confidential. So it's kind of really important. It has to be made under seal. This is the first part of the notice. And there's also another part. It's down here. Okay, so let's look at it. So it's an individual who files a lawsuit for retaliation so this is for anti-retaliation. This is related to anti-retaliation lawsuits. So you can use trade secret information in an anti-retaliation lawsuit. An individual who files a lawsuit for retaliation by an employer for reporting a suspected violation of law may disclose the trade secret to the attorney of the individual and use the trade secret information in the court proceeding. Now, this is a big if, but let's break down what this basically says, because actually it's a little tricky. But basically, what this is saying is that if your employer fires you for retaliation, let's say you make a complaint and then they fire you, that's where this would apply. So if they fire you and you're suing them for anti-retaliation under anti-retaliation laws, then it would be possible for you to possibly fall under this section of the provision. Let's see when it's okay for the individual to disclose to their attorney and to use the trade secret information. So if the individual files any document containing the trade secret under seal, now this is an and, again, I'm going to highlight it because both of these have to be true, right? So it has to be a document that's filed under seal. And the second requirement is that it does not disclose the trade secret except pursuant to court order. This means that if you are in an anti-retaliation lawsuit, you can't just file a paper, okay, under seal. That's not going to cut it. It has to be pursuant to a court order. Otherwise, you're not going to satisfy this exception under B. So it does not disclose the trade secret except pursuant to court order. So it has to be pursuant to court order. That's the only way that you could be able to satisfy subsection B. Okay. So this is the notice. Okay, but we haven't even yet discussed what you as an employer are required to do. Okay. Why do we generally do that? Well, written in writing, it's got to be provided to the employee. Okay. If you do not provide the proper notice to your employee, then you're going to run into this situation right here. If an employer does not comply with the notice requirement, the employer may not be awarded exemplary damages or attorney fees. This is huge. This is huge. This basically takes the teeth out of the Defend Trade Secrets Act. So if you didn't have the proper notice, then you're not going to want to sue in federal court under the DTSA because you're not going to have the opportunity to collect exemplary damages or attorney fees. So very, very important. Very important. You must give proper notice to all your employees. One is the applicability. So when does this apply? Like, who do you have to give notice to? And it's for all contracts and agreements that are entered into or updated. Remember, notice the word updated. Very important. Updated is a very key word, okay? After the date of enactment of this subsection. So if you update your contracts or agreements, you're going to want to make sure that you include the provision language, even if the employee was hired before the DTSA was enacted, which I believe was in 2016. If, let's say, you hired an employee and you had an agreement with them, but that was before 2016, well, then I would agree that this probably subsection D, that the notice provision wouldn't apply to that particular employee. But let's say you updated their agreement. President Obama signed the DTSA into law on May 11 of 2016, and it became effective on May 11, 2016. So it was actually the same day that it was signed into law, it became effective. So basically all employees that you entered into agreements with after May 11, 2016. So basically now until the future, you need to provide this notice provision. And again, if you do not provide the notice provision, then remember, you're going to run into issues with being able to collect damages and attorney's fees. Remember, attorney's fees are huge because if you prevail under the DTSA, then you could be entitled to all your attorney's fees. So it gives you a huge amount of leverage, especially if you have a really solid case. Now, this is really good because it basically says that cross-reference to a policy document is acceptable. So you can provide a cross-reference to another document, a separate document. One thing I want to also point out is it talks about what an employee is. So the purpose of such term employee influence any individual performing work as a contractor or consultant for an employer. Guys, this is huge, okay? This is huge because there's a lot of litigation around whether or not an individual, and not limited to litigation, but also controversy and policy around who qualifies as an employee or a contractor, okay? So the fact that you're a contractor isn't going to get you out of this, okay? So it's really important that you provide this notice to all your contractors. This is very, very important, guys. So this is a sample independent contractor agreement. Here it clearly is showing the notice provision that we have in our agreement. So again, let's say that you're hiring, let's say I'm hiring Victoria to perform some services for my company as a contractor. Again, this also applies to employees, definitely to employees, but also to contractors. And the reason why I want to make this video about contractors is because a lot of people, a lot of companies are engaging with contractors. And so it's really important that if they're going to have any sort of proprietary or confidential information, you're going to want to have this provision. Just be safe. Just put it in there anyways, because you don't know. You don't know, the scope of the work might change. It might become more expansive. Somehow you might forget the fact that they're getting a hold of confidential proprietary information. You don't want to be in the situation where you hired them without this, entered into this agreement, didn't provide them the provisions, and then they somehow got a hold of confidential information, and then you're stuck with no damages under the DTSA. So very, very important. Just be safe. It's literally 3 paragraphs. Put it into all your employment and contractor agreements, and it'll save you a lot of headaches in the future. Let's scroll down. So this is our standard just independent contractor agreement. Just to close out the episode, I just want to show you guys, if you go down, we have this notice provision right here, notice under the Defend Trade Secrets Act. So again, you're going to see this is the exact same notice that we just read from the code. Well, almost. I mean, I have the structure of the language is a little different, but fundamentally all the same words are in here. They're just organized and formatted a little differently. So the DTSA, again, that stands for the Defend Trade Secrets Act, provides that an individual shall not be held criminally or civilly liable under federal or state trade secret law for the disclosure of a trade secret that, and then this is the first part, so is made in confidence to a federal, state, or local government official, either directly or indirectly to an attorney, this is key, and solely for the purpose of reporting or investigating a suspected violation of law. Okay, so this would be one basis for why an employee might lawfully disclose a trade secret. Okay, one of your trade secrets. Okay, but that's why this notice is so important, because they need to know that this is an option available to them, right? There's a public policy reason for this, right? So if it's for reporting suspected violations of law, they need to know that there is a possibility that they might be able to lawfully disclose a trade secret, complaint, or other document filed in a lawsuit or other proceeding, if it's made under seal. So it has to remain confidential. It can't ever become public record, right? Otherwise, you will not fall under the safe harbor, under this immunity provision of the Section 1883. Let's look at the second part of the 1833. Okay, so, and then in addition, the DTSA further provides that an individual who files a lawsuit for, this is key, retaliation by an employer, okay? So employer retaliates by firing you. Let's say you complained, coffee's bad in the coffee room, something, I mean, whatever. And then the employer retaliates against you for reporting some violation of law. Okay, I guess the coffee example wasn't very good, but it has to be for reporting a suspected violation of law. Then you may disclose a trade secret to an attorney of the individual. So to your lawyer, okay, very important. You can't just post it on a blog. You can't tell your friend Sally about it. It can only be to an attorney, okay? And use the trade secret information in the court proceeding. This is an and, right? So it's both. It's got to be a court proceeding, right? So it's not just you just tell your attorney and then they use it to do something other than as it relates to the proceedings. So that's really important. So they can't just go to the press with it, right? It's got to be, they have to use the trade secret information in the court proceeding. And these are the requirements. So the individual files any document containing the trade secret under seal. Again, this is a really important and. So it's got to be under seal. It's got to be pursuant to court order. So 2 really, really key requirements. So again, this is the DTSA employment notice.